Good morning, everyone. Welcome to today's webinar. Today, we'll be discussing how to terminate a condo association, going through the process, the legality of it, understanding if there's any potential liabilities, what it's like to be a manager and going through this particular process. So it's been a hot topic. You're seeing it come throughout the newspaper, throughout South Florida, and I'm sure it'll be probably throughout the entire state in itself, especially with the new legislation, or no longer new, but more than 2 years now, but with the legislation requiring structural integrity reserves and, making associations have the necessary reserve funds. So we found it to be very important for us to go over this topic, give board members, managers, potential partners, an understanding of how the process works. And that way you could leave with at least a couple golden nuggets that you need for your association and how to deal with this particular situation. So I have the great pleasure of having Lindsay here from Siegfried and Rivera. So Lindsay, maybe if you could say a little bit something about yourself, your background and the firm.
Of course. Well, thank you for having me here today. I agree. This is a hot topic that we see coming in probably at least twice a week on my desk. My name is Lindsay Lair. I'm one of the shareholders of Siegfried Rivera. We are a boutique real estate community association and construction firm. Our firm represents over 600 community associations throughout South Florida, from Orlando all the way down to the Keys. My practice involves mostly community associations and development, representing primarily community associations, a few developers, and construction litigation as well.
Excellent. Thank you so much, Lindsay. I know that you're an expert in this field, so we're honored to have you on today's webinar. As for myself, my name is Rafael Aquino. I'm the co-founder and CEO of Affinity Management Services. We're a community association management company. Basically, our proven process is what's given us the opportunity and the privilege to grow. And that's basically aligning to our association's vision, executing on it, and then providing guaranteed results for our community associations. We also service all of South Florida, growing into now Colliers County. And eventually, hopefully, Lindsay will be working together in Orlando as well. But besides that, I think really what you're here for is to go over this topic and get a stronger understanding of how these condo terminations work. So for those of you that have any questions with regards to this particular topic, I kindly ask you to use a Q&A. I'll do my best to get those questions answered, assuming that they're related to the topic. And for those board members that couldn't get your other board members to attend, we will be posting this on our social media platforms. I'm sure Siegfried will do the same, and we'll be sharing the video as well. So with that said, I think we'll go ahead and kick off this webinar. And Lindsay, I'm going to start with pretty much the kind of give a high level of what are the legal steps that are involved in terminating a condo association.
Yes, so terminations of condominiums are governed by Section 718.117 Florida statutes and also the Communities Declaration. Right now, as it stands under 718.117, in order to terminate a condominium, you need 80% of the total voting interest to approve the termination, unless it says otherwise in the declaration. It's important to make sure when a termination is being presented that a review of the documents are conducted, because if there is a conflict and if the documents do not incorporate what's known as Kaufman language, where amendments to the statutes are automatically incorporated every year, then the governing section of 718.117 that will control will be that as set forth in the declaration, which may be when it was originally recorded, let's say 40 years ago.
Correct. And that's a great point that you bring up the Kaufman language, because many, board members, I've heard that, they're just, it's 80%. And in reality, they do need to first look at their condo documents to determine what are the requirements? Because it could be different if they don't have that as amended from time to time language within the document. So first step, I guess, for our listeners is make sure that you're contacting your attorney if this is something that you're interested in potentially doing, and that way you know where you stand. So Lindsay, when it comes to making sure that they're adhering to those documents, what steps do you recommend managers and board members to take?
Yeah, so it's as you said, really important to consult with your attorneys and review the documents so that you understand what the required vote and threshold is in order to conduct a termination, and whether or not a plan of termination is going to be presented and what type of vote needs to be held. As I mentioned, regardless of whether we're going under the current statute or in the declaration, there will be some sort of membership vote that's taken with at least 14 days notice, and or the termination can be approved by written consent as well. But just really important to make sure that you're reviewing the documents, because like you said, there everyone usually says, oh, it's 80%. Well,
Right.
it may not be 80%. And that's definitely step one on how we move forward.
Okay, great. Now, prior to us jumping onto this webinar, I know we were discussing that you've seen an uptick on condo terminations and so forth. So could maybe you give me a bit of an example from, let's say, an association side, where how does a board normally get approached for a termination? Is it something that you're seeing that board members themselves are considering with the residents? Or are you seeing more of maybe developers that are approaching these associations and saying that they have some kind of interest? If you can kind of give us some insight of how you're seeing, or maybe from both sides as well.
Yeah. Well, with the requirement for structural integrity reserve studies and reserve funding that's coming up at the end of December 2024, a lot of communities have budgetary constraints that they're being faced. I mean, their assessments are going to go up for many communities that have either deferred reserves or waived reserves, and significant maintenance is required. So typically what we're seeing is in situations where communities may not have the funding necessary, they're reaching out to real estate brokers to try and shop their properties. And also developers are constantly surveying those waterfront
Mhm.
properties to somewhat target them, also doing a review of the governing documents. So I think if a board or management has some interest in potentially marketing their property, it's definitely recommended to consult with a real estate broker who has experience in these types of sale transactions. And also developers, like I said, are constantly asking these real estate brokers for properties that may have interest as well. So there's constant communication that I think is available if the interest is there.
Okay. And then when it comes to the board, so let's just say, because you bring up that important point with the structural integrity, I'm also of the opinion that I believe we're going to see much more condo terminations coming out in the news over the next coming years. So as a board, let's say that, the board feels, okay, you know what, we should put this property up to market. Is that a board decision, or what steps do you recommend the board to take? Should you say, okay, if the board's okay with it, we go to market? Or would you say they survey the residents? What steps would you recommend?
Yeah, I'm a big proponent on transparency and open discussions between the board and the unit owners regarding this issue. Even if a board member may think and support a termination and sale of their unit, all board members are fiduciaries and need to make sure that they're acting in the interest of the community at large. So having those open town hall discussions and polling are definitely recommended, and in order to get a sense of what the community wants and how the community wants to move forward. Because if the termination is allowed under the current version of the 718-117, there is the right of 5% of the voting interest to block the termination. And if the community is not appropriately supporting it, all the effort that can be done in order to market and gather support could easily be stopped.
Correct. And let's say that that 5%, and that's, I'm assuming, kind of to give our listeners really the fifth grade side of it. Maybe if you could explain what, let's say a proposition is provided to a community association that we have an interest to purchase your property. What kind of plan or what's put together in order to present this to the members of the association?
Yeah, well, what I'm seeing with the uptick in terminations is that developers are really aiming for 80% and above of the voting interest to support the termination, and are sometimes willing to risk moving forward with getting sales contracts with a percentage above 80%, and then somehow taking control of the association and later getting the any additional approvals or sales contracts in place in order to move forward eventually with the termination. But if a plan of termination is presented, it's shared with all of the unit owners, and the owners have the opportunity to vote to approve, disapprove, or abstain from voting on the termination. What is key is, if there is an objecting owner, you need to voice your objections. When you see those offering circles going around and the meeting for the plan of termination, don't wait until the plan is already approved to voice your objection. It's important to stay in front of this, voice your objection, get an attorney to try and protect your interests if it is in fact your desire to oppose a termination and try to stay and retain your property rights.
Yeah, and in preparation for this webinar, I was reading one of the partners there at Siegfried. They wrote an article of some people purchasing a significant amount of units and gradually or instantly increasing the maintenance fees to kind of force out the other residents. However, it's very difficult to prove if they're doing that for legitimate reasons or for other reasons. So I think it's important, as you mentioned, that if there is a plan for you to voice your particular concern. So what happens if, let's say, that 5% number do voice their concern and decide that they don't want this to happen? Are there any timeframes that tie them from not being able to do this in the future? If you could talk a little bit about that.
Yeah, so the current 718.117 version says that if 5% of the voting interests object to a plan of termination, another plan of termination cannot be presented for another 24 months.
Wow.
So that's definitely a puts the developer, the terminating entity at a pause, but it's also, everyone needs to be mindful that most likely the developer, if they have already purchased a significant voting interest, they will be trying to get support and going again for the termination in that 24-month time period, or after the 24-month time period.
Yeah, I'm sure most developers aren't buying 80-90% of a building to just be on the board. I'm sure they have other
Correct. And
interests.
that's right. That article that you mentioned is definitely something that we're seeing. I mean, I've seen a lot of news coverage regarding high maintenance assessments that are being proposed by entities in order to sort of force communities into termination. Of course, with the reserve funding requirements, those lines and the budget, as I mentioned, for the communities will be going up one way or the other.
Yeah, correct. So I actually had a situation pre-SIRS, structural integrity reserve, sorry, pre that, back in 2019-18 in that Miami Beach area that's kind of being completely updated, where they did a termination. The building was okay, needed a ton of repairs and needed updating. And the owners benefited. Every single owner pretty much was paid 30% over market value. Maybe today they're kicking themselves in the butt, but no one would have predicted that back in 2018-19 that we would be where we are today. But overall, everyone turned out, pretty well, getting paid over 30%. Obviously, this was a prime property, prime location, so the developer paid a significant amount. It did take some time because you had some owners holding out. But ultimately, it did occur, and it was a success for everyone. So I bring this up because I know we had a question prior to the webinar when it comes to, let's say, board members having any liability for presenting this or going through this process. Maybe if you could touch up on that, if there's any liabilities or any concerns that board members should be on the lookout, or potentially even any conflicts, if there's the statute touches on any potential conflicts.
Yeah, so there are conflict of interest provisions in the Condominium Act that board members need to be aware of. And what I mentioned earlier is transparency with the unit owners, membership meetings, trying to get a pull of what the community desires when facing a termination is really important. For board members individually, and management, I recommend that they try to remain neutral. If a board member is in favor of a termination or is opposing a termination, you're certainly allowed to vote on behalf of your unit. But when actions are being taken by an association and the board of directors, those actions need to be more of a advisory role for the community and not as to the personal interest of that board member.
Of course. Yeah, it's always important to have that transparency. And I think, for many associations, I really do believe, again, that this is going to be something, for some, probably the only option available. So it's important, as you stated earlier, to start those town hall meetings if they feel that this is a viable option. It doesn't hurt, no different than maybe going out to market to get a proposal for landscaping or for cooling tower repairs to see, okay, where does the market stand? Have that communication with your residents and say, look, well, this is what we're expected to have for reserves. This is what the mandatory requirement is going to be, whether it be 5 million and you've never had any reserves. That's a significant impact, especially if your building is full of individuals that are on fixed incomes. They may not be able to afford it. So it doesn't hurt to really go to market, get an understanding, okay, speak to some professionals that specialize in condo termination, because there are brokers that deal with these large asset classes. And that way they can see, okay, look, this is what you're looking, price per square foot or price per unit, however they come up with their figure. And that way you can present that to the membership and you can get the conversation going. What I would recommend from a management point is not waiting till the last minute, because that'll put you in not a position of leverage to be able to try to maximize the dollars that you could potentially get for your association.
And I think with the number of communities that we are going to be seeing with budgetary constraints and increase in assessments, the pool of available condos that are up for potential termination is going to increase, which will impact significantly the price that developers are willing to pay above market in order to terminate these condominiums. And that's definitely, I think, a trend that I've been observing in my practice.
Interesting point. Very interesting. And, the tougher condos that are probably going to have a little bit more of a challenge is more the inland, associations, because obviously if you're on east side of town, there's going to be a premium just because of the potential zoning that exists for that area and so forth. But either way, it doesn't mean ignore it, the fact that there is this viable option out there, because maybe someone wants to convert your condo into an apartment complex or an Airbnb style product. So again, it's just really thinking outside of the box, finding solutions that are going to work for your particular association. And like we always like to say, every association is different. It's its own organism. So you got to figure out what's right, and then just speak to the professionals that could potentially guide you. I have a question here from Rosanna that relates to the topic. Her question is, with regards to, let's say, structural common elements, utilities like green areas, pools, how would that be addressed if the termination is approved?
So as part of the plan of termination, all of the association's assets and property will be transferred to the termination trustee, and the distribution of those proceeds along with the liabilities will be set forth in that plan of termination, typically with the liens and mortgages being paid out first, and then any excess or surplus funds distributed to the unit owners, typically in accordance with the proportionate share set forth in the declaration, the same percentages that the owners have to pay for assessments associated with their units.
Okay, great. And let's say those long-term contracts that some of these buildings have, let's say like bulk, normally those are pretty long agreements. Elevator agreements are usually about 5 years. Trash agreements, all depends. Most of those are what I call hard contracts, where it's difficult to be able to get out of those agreements. Does the association end up negotiating out of those agreements, or because there's a transfer in ownership that changes the terms? What have you seen in your experience?
Most often, those service contracts will remain and be transferred to the termination trustee, and then will be responsible for, or be the responsibility of the entity who ultimately becomes the owner of the terminated property. Because more often than not, even when the condominium is terminated, there are provisions for potential leasebacks or honoring existing leases. So the property still will need to be maintained and kept in a habitable condition for a significant period of time before the plans are approved for whatever development is ultimately set for that property.
Excellent. Yeah, and that's a great point that you bring up, because we experienced a similar situation where they did leasebacks. That was part of the negotiations of, they couldn't get to a number that the owner wanted, but they gave them a year at the property for free. So those are different things that obviously those are negotiation tactics that are used when you're going through this process. But that's a good point to mention, because I know it's come up in the past where, what happens with these contracts? Are we going to have to pay them out? And does that come out of that total number that we're going to be paid? So it's good to hear that would transfer over. And
Yeah.
from your, I'm sorry, go ahead. Oh, and
I was
from
going
your,
to say, and what we are seeing is when a condominium is interested in termination, when they're working with real estate brokers, we're also working on form contracts that are negotiated by counsel for the association, so that fair terms are presented to all of the unit owners that both represent the interests, such as you mentioned, leasebacks or addressing liabilities, so that the owners have a better understanding of what the potential payout is and what will happen with their asset, and potentially moving out provisions going forward.
okay, excellent. And when it comes from your experience, because you dealt with them in the past, how long do these terminations take? Let's say once the proposal is provided, the termination plan is approved. About how long have you seen in your experience that it takes from that plan approval to, let's say, the actual closing of all the units?
So under 718-117, I typically see at least, I'm just going to go a little bit forward from your question. It's usually a minimum of 90 days before the plan is presented, and then a minimum of 90 days for recording of a plan. So that's about 6 months, 3 months before, 3 months after. Closings are something, like I said, in those real estate contracts that can be negotiated and are often negotiated. What I am seeing typically in these types of terminations is that developers are giving owners time to move out, because they understand that with the number of units being purchased and individuals living there, that they do have to make accommodations. So I would say typically at least 3 months will be given for closing once the contracts, or once the termination has been approved and the contract signed.
Okay, excellent. Yeah, and I'm sure that's all dependent too on the developer and so forth, of how long they take to get their financing and so forth. But okay, those are good timelines to have. So Michael, I have a question for Michael, pretty creative. Not sure if you'll be able to get to it, but he basically asked, he's aware of the new law that's coming out with structural integrity. And he's wondering, is it possible to terminate, instead of terminating a condo, switching it from a condo to an HOA in order to avoid new condo laws and hefty special assessments? So I guess switching the association from a condo association to an HOA.
Yeah, so very creative question. The difficulty with converting from a condominium to an HOA is, so there are different provisions governing Chapter 718 and Chapter 720, and that includes structures on maintenance, common elements, and so forth. But just to answer your question, that type of change may be considered a significant impairment of contract rights of the unit owners that would require 100% approval of all owners and mortgagees, and also legally not feasible.
Yeah. It's tough enough to get 100% of the owners. I can't imagine trying to get 100% of the mortgagees. So yeah,
And also the structural
yeah.
concerns and legal challenges that the protections that 718 afford to these types of developments. It's governed by Chapter 718 for a reason and set forth in the declarations because of
Okay,
that.
excellent. So I kind of want to switch gears now. We kind of went over the questions that board members would have with regards to a termination. Now, in some instances, you're seeing some of these terminations where there's a management company or there's a manager already there. They're in the process of the termination itself. So what's the role of a community association manager, let's say, during this termination process?
Yeah, very good question. And for managers, it's really important to make sure the finances are up to date so that appropriate accounting can be given so that owners and the developers are aware of what the liabilities are and how assets are going to be distributed, what type of surplus funds, if any, and reserves are on account. And really for managers to just stay on top of it, be transparent, encourage your boards to hold town hall meetings and board meetings to discuss these issues and answer questions as much as possible. And again, as you mentioned, rely on your consultants.
Yeah,
Talk to the real estate brokers, consult with your attorney, talk to your neighboring managers to see how these negotiations are happening and who's being approached so that you can stay on top of this and give at least sound recommendations to your board on what you're experiencing, observing.
correct. I would agree with you there. I mean, it's no different. You're a professional, so ultimately you have to keep on, playing the role that you were hired to do. So whether the termination is going to happen or not, honestly, I'm obviously there's probably some clauses where they can get out, assuming if there's certain due diligence is not met. So ultimately, your responsibility, I would say, as a manager, to continue to do what you were hired to do there. And then once the plan is approved and let's say they're past their due diligence, it's just continue maintaining the building and managing the contracts, managing the relationships. And that way, if you're being a professional in and a professional out is how I like to say it.
Yeah,
So
that brings up a good point because I have been involved in a termination that was challenged because of inaccurate disclosures.
mm,
So really important that all requested information regarding lawsuits, any liens, any unit owner disputes, all of that has to be answered truthfully and fully in order to make sure that the association is at least complying with its obligations under the purchase and sale agreements that are being presented by these developers.
correct, correct. Yeah, again, we keep harping on the same thing of the transparency piece, making sure that we're communicating throughout the process and letting all the residents know of what's going on. No different than if you were passing, I guess, a special assessment or anything else that you're doing within the association. The more transparency you have, the less of a possibility of being challenged on that. And the last thing you want is if you're receiving above market value for your building, the last thing you want is a deal to die. You want to make sure that you're dotting all your I's and crossing all your T's. So I have a question here from Anthony, and I'll take this one. What is the benefits to the condo owners, I guess, if there's a termination? So Anthony, kind of overall, it's a discussion that we're having now. It has to do really with there's going to be many condos, and some are already in it, when it comes to the requirement of the structural integrity reserves or buildings in certain instances that just haven't done the proper maintenance or haven't addressed the concerns that they've needed to address over the years. And unfortunately, now they're in a position with the combination of not doing the preventative maintenance that was needed for years, the requirement of the structural integrity reserves, everything that has to do with milestones and so forth, where they're being placed in a position where you may have no choice but to sell, just because the maintenance fees are probably, in some instances, much more than probably everyone's mortgage within the building. We're seeing this across the state, but this is really what would be the benefit to some condo owners. In my experience, in the two terminations that we've been part of, the owners have benefited. It hasn't been a situation where none of the owners didn't benefit. They were paid above market value. I'm not making a statement that everyone will, but ultimately, at least from my experience, I have seen where the owners benefited from that change. So I do have a question with regards to, let's say you have associations, especially these associations that maybe are in the midst of a lawsuit, are in the midst of, a claim with their insurance company, and they get approached. What are the implications there? How should a board or management handle those situations?
Yeah, that definitely goes back to full disclosure and transparency with the developer so that the purchasing entity is aware of the potential liabilities involved in a lawsuit. And the plan of termination usually will address how the litigation is going to be handled, and the association or the termination trustee will be able to continue to prosecute or defend, and whatever happens with any judgment or liability will be addressed in the plan of termination. So as long as it's disclosed and provisions are made and included in the plan of termination, any potential future exposure, or as you said, overturning or canceling a sale because this was not disclosed, will be eliminated.
Okay, excellent. I have a great question here from Susan. And Susan asked, during the termination, are board members given the opportunity to become interest holders with the developer? As an example, they become part owner of the development company.
No, I have not seen that. And doing so as a board member may be deemed a conflict of interest so long as if it's not appropriately disclosed, because under Florida law, board members can be held liable for breach of fiduciary duty if they take actions which are considered self-dealing or for personal financial gain. So really careful if you are approached in that sense, and make sure that appropriate disclosures under the statute are made so that it's disclosed and voted on by non-conflicted board members.
Yep, disclose, disclose, disclose. So I have another question here from Loria. She asked, what if a unit has a mortgage of more than the purchase price offered at the termination?
The statute and typically the declarations require that when there is a mortgage on a unit, mortgagee consent is required to approve the plan of termination. So if there's a mortgage that exceeds the purchase price that's offered, the consent from the mortgagee will be required. And I have, just as you mentioned, I have yet to see a case where that happened. Typically, the offers that I've seen thus far exceed any mortgage on a property, but it certainly is a possibility.
Correct. Yeah, I could see that a possibility, especially maybe someone that just purchased a year or two ago. So, in comparison to someone that purchased 10 years ago, it'd be a different situation. But ultimately, you have to look at what's going on within the association, because it's, just like any investment, sometimes we don't want them, but loss is part of investing. No investment is risk-free. And you may need to weigh, maybe it's a $10,000 shortfall, but what you were looking at special assessment wise was going to be $20,000, $30,000 for that particular building. So again, every building's different. I think you'd have to look at it and make a business decision. Obviously, consult with your attorney and accountant, and that way they can provide you the best guidance necessary to put you in the right position. And when it comes to the managers themselves, when you've seen these terminations, when these terminations occur, typically, I'm assuming they're still going to they still remain a condominium for some time, or do they get converted immediately into, let's say, an apartment complex, or does that change immediately, or is that's a process that normally happens after?
So once the plan of termination is recorded, the condominium, and it's sent to the DBPR, the condominium status will be terminated.
Terminated. Okay. Perfect. Excellent point. Yeah, that way everyone kind of knows that that point. And how do let's say homeowners that fall within that 5% that decide not to do it. How do they decide not to do it? Is it a vote that's normally done through some kind of proxy or at a meeting? how does that 5% voice their concern or their
Yes.
non-interest in making that termination happen?
So once a plan of termination is presented to the unit owners, there will be notice, 14 days notice, a membership meeting held, and there will be a vote at that meeting typically to approve or disapprove the termination. And in order for the 5% to object and to issue a dissenting vote, they have to do it in writing, vote against the termination, and voice that objection to the association within that time period.
Okay, now is the 5% of the building, or is it 5% of the 80%?
5% of the total voting interest of the building.
Okay, perfect. Excellent point. Okay, I have a question here. Is there any advantage? We already went through that. Yes, I guess I can answer this. They're basically asking if our maintenance or reserve requirements still the same for the condominium, but you already addressed that once the building is terminated, then technically they're no longer a condo association. So, and ultimately I brought we wanted to address that point but ultimately that will be the responsibility of the next party that needs to address those concerns. That would have nothing to do with either the owners or the board of directors. Question here, when it comes to a termination, let's say you're in the midst of a annual meeting and your documents state it's in December, condo is going to get terminated in March. Do you recommend the association still continue with their due process, or what are your recommendations there?
Great question. Always continue on with the operation, maintenance, and management of the association, because while you may think you have the approvals and the condo is going to be terminated, until it's actually terminated, it's not terminated. And the board and management are obligated to comply with its obligations under the documents and law.
Okay. And let's say there is an agreement, it's moving forward. The association has, for argument's sake, $1 million in reserves. Is the developer purchasing the entire organization? Like when you purchase a business, are those funds normally distributed amongst all the owners? What's done with those funds that are currently in the association's possession prior to termination?
Yeah, so this is something that I definitely recommend that is included and disclosed and determined in those purchase and sale agreements that are being negotiated between the purchasing entity and the unit owners. Oftentimes, if the developer or the buyer agrees, the funds and surplus will be distributed to the owners, but it all depends on what other liabilities may exist. So really important that those purchase and sale agreements are negotiated and all funding allocations are determined and agreed to in those contracts, because that is what is going to be followed.
Okay, makes sense. Yeah, goes to show again the importance of having strong counsel by your side, because that could be a significant amount of money. I mean, those are negotiations that you need to know ahead of time where you stand. That way you have a good strategy. If you're strategizing to do the termination, obviously, if you get approached, you should still have a strategy anyway, because now you have interest. So now you have leverage, in my opinion, so making sure you keep that top of mind, I would say it's very important. That way, if you could distribute that's an extra, whatever it may be, 1%, 2%, 3% of the market value of your unit. And that's something that may possibly help maybe that 5% that has no interest in moving forward. So I think that's important to mention.
Yeah.
So let's touch a little bit on, someone had a question here when it comes to these forced condo terminations. So I think what they're asking has more to do, let's say someone comes in, buys a significant amount of shares, let's just say 40, 50%, and they start to pass special assessments and upgrading, doing what they believe is right. And who knows, it's hard to say that that's their intention, but talk to me a little bit about that. Is there anything that residents can do or board members can do if this person took the majority share because they have the majority of the units? Talk to me a little bit about that and what's been your experience there.
Yeah, well, so for the forced sale process, because I saw that question pop up too, the statute requires that an appraisal of the units be performed and a fair market value appraisal be given at least 90 days prior to the recording of the plan of termination. Once the plan is recorded, that appraisal will be shared with the non-approving owners. And if it's rejected, there needs to be a basis. This could only be based on fair market value, not other considerations. And if there is a ultimate dispute on what the fair market value is, there is a process for dispute resolution under 718 where the DBPR will address the termination, the value, and what the differing numbers come up to.
Yeah, yeah. Yeah, I mean, you are going to see it. Everyone has a different approach to business. You know, some people are going to be a little bit more transparent when it comes to the potential termination, and you may have someone working incognito. You know, they may be purchasing no difference than Disney did in purchasing all the land that they did years ago. So, you know, you as a resident, it will be very difficult. I think it's just staying active, understanding what's going on, as we've mentioned throughout the webinar. Nothing should change, whether if it's a majority owner and they may have partial control of the association, they're still required to provide financial documents, required to provide meeting minutes, the decisions that are being made, and so forth. And if you're a resident and you're put into that position, then you may have no choice but to actually hire your own counsel to protect your interest. So again, these are very difficult to answer and provide a precise answer. But ultimately, you know, you do have options. It's just speaking to the right professionals to address those concerns. So,
Yeah, and I think the key is for unit owners who are objecting or facing termination, it just when you start to receive those notices, make sure you stay on top of it. Don't wait until the plan of termination is recorded. You want to be ahead. You want to join with other unit owners and try to get your 5% to object to the termination. If you wait and it's too late, you're going to be in that bucket of the owners who may be forced to sell and under unfavorable terms.
okay. And that plan of termination, is it drafted, let's say if it's a developer coming in to purchase the property, is that drafted by the association's attorney? Or do you see normally that the developer comes with an initial plan and that gets presented to the association's counsel?
So I've seen it done both ways. Typically, the developer has counsel and has terms that it wants to present and a plan on, as I mentioned, how it wants to deal with occupied units, leasing, and so forth. So if a developer asks an association to move forward with a plan of termination, again, that's something that we just need to make sure is the consensus of the community wants to move forward. That plan is presented, but typically the associations and the developers council will communicate in order to make sure that both the unit owners and the developers' interests are both addressed.
Okay. And an association that's looking to market their property, would you say that they should market it in a similar fashion already with a pre-drafted plan? So they contact you, Lindsay, and they say, look, we want to put our property up to market. We've already found our broker. Should that come already with, hey, these are the terms that would come with the potential sale, or do you recommend negotiating that later down the line once an offer is provided?
I think what I typically see is that the brokers take the lead on finding properties, marketing them for sale, and those specific terms are negotiated once a select buyer / developer is negotiated or determined. But there is some sort of offering circle and basic terms that are presented by the broker.
Yeah.
And that is definitely recommended. Those key items that the owners want to make sure are included in the purchase and sale. Say owners want to have a year of occupancy. Those types of things need to be included in the offering circle so that when the letter of intent is sent by the buyer, everyone is aware and agreed to on those basic, really key important terms.
Correct. Yeah, I agree with you there 100%. I think some of the points that we've discussed throughout the webinar of, what's going to happen with the bank funds, that should be disclosed. What's going to happen with the agreements that the association already has, that may be disclosed. So again, if you're in that position, then I think it only makes sense to make a small investment of, sitting down with the attorneys, what have been your pros and cons, what's worked, what hasn't worked. What should we put in the basic terms? Maybe not having the plan, as Lindsay said, but at least knowing, letting your broker know, look, these are non-negotiables. This is what we need you to execute. And then, that way the person coming in already knows where you stand. So I have a question here, pretty good question. I think for those that don't know, is termination only viable if there's a developer or a buyer for the property?
No, so in Florida, there are two types of termination. There is a voluntary termination, and originally the termination statute was created more for communities devastated by some sort of natural disaster when the rebuilding was unreasonable or not feasible due to the financial constraints of these communities, for perhaps communities that were damaged by hurricanes and so forth. But to answer the question, no, a termination can be proposed or can be approved by unit owners unrelated to a developer, and as long as a plan is in place, but you will need, if it's governed by 718-117, a termination trustee to take over and determine how the assets are going to be distributed and so forth. If 718-117 doesn't apply, some older declarations provide that once the condominium is terminated, there's an action for partition and a sale, a public or private sale. So that is another option for communities whose declaration provides for the action of partition.
Okay, interesting. And Enza asked a question here. Is there any way of stopping investors from buying units slowly to reach that majority?
Good question.
Great question.
Like I said, I think the key for objecting owners is to voice your opinion, stay on top of it, communicate with your other owners, try to get a group of owners who, like you, are opposing the termination, and obtain counsel to see what you can do to try to work together with the 5% of owners in order to stop the termination and show the developers that this is something the community is not interested in.
Yeah, that's a good point. Yep, getting your troops already in line and advising them of what's to come. So quick, this has just popped up in my head as you were mentioning that. Is there a way of putting in the documents? You know how you can't rent, units that can be put into, you can amend the language, or is there a way of amending the document saying we can only have X number of corporations within an association?
So there's been a lot of litigation regarding restrictions on the number of units that a particular person can own. Those types of amendments have been deemed unenforceable as restraints, as improper restraints on alienation. There is crafty language that can be included in order to discourage types of bulk sales. I would definitely recommend consulting with your attorneys because, like I said, the declaration is a contract. It's the constitution between the association and its unit owners. And impairments of those contract rights, which change the rights of the owners as they originally purchased, will or may be deemed by a court unenforceable and legally of no effect. So while communities often amend declarations to have favorable terms that the owners currently want, it may be deemed unenforceable eventually.
Yeah, that makes sense. Sorry, Enz, I was trying to find you a creative solution there. So I have a question here from Laura. She asked basically, what happens if 80% of the units are purchased by a board member? Then this board member sells it to a bulk buyer, and then the bulk buyer takes over with a speedy plan of termination. Do the remaining owners have any recourse?
Sorry, I wanted to read it
Yeah.
myself.
And then you correct me if I'm wrong. I'll let you read it. I believe, I think that they can put the plan together. Obviously, they have the vote, But if you have that 5% that stops it, then and takes the vote to stop it, there's 24 months that they can't do anything. Correct me if I'm wrong there, Lindsay.
Correct. So even if 80% approves under the current law, and again, we'll go back to the original comment, you need to make sure what termination provision applies to your condominium. But under the current law, even if 80% approve, 5% of the voting interest can object to the termination. And to go back to, I believe, the comment that you had, or that I believe Enzo raised regarding what can be done, what type of amendments, the association can amend its documents to change the termination provision and what termination vote is required. So we've seen developers change to incorporate the current version, to incorporate Kaufman language, to incorporate amendments to the Condominium Act, and to reduce the percentage. We've also seen communities increase the required vote to terminate. So all things that can be considered, but overall need to check what the documents require, because some documents that I've seen specifically say that the termination provision cannot be amended absent 100% approval from the owners. So really important that the contracts are read and followed.
Correct. Yep. Council, contacting council and, making sure that they go through, and that way you put together, the right strategy to try to stop or assist whatever you're trying to do within your association. And back to that question with the 80%, I would, if I was that 5% that didn't want to sell, I would actually have the conversations as well, because you could be put into a position where you're put into that forced, that forced termination, where maybe they don't put a plan together, but they say they need to upgrade the roofs because the roofs are 15 years old. It's going to be hard to prove that you don't need a new roof. It's going to be hard to prove that you don't need to upgrade the common areas, because now they have the vote to make amendments to the use of those common areas. So, you got to think of it from all angles. So then that way you have the right approach for your benefit. So you have to be very cautious if that is the situation. Susan,
and with the reserve funding requirement, if a reserve study comes back extremely high, the developer or whoever the buyer is that purchased a majority of the units could certainly impose a huge budgetary increase based upon the reserve study alone.
Correct. And those are opinions. So who knows what opinion they get and from who they get it. So
correct. That was my point.
Yeah. So Julia has a question here. Is there a resource to learn about co-op termination? Both of those owning the land and those with land leases?
Yes, so that is also governed by statute 719, and terminations are set forth therein.
Okay, excellent. And then Susan asked a question with Kaufman language. Are you saying it could be less than 80%? I don't believe that's what you're saying.
No, I was saying that an amendment to the declaration can be provided that changes what they're in all and so I shouldn't say in all. In most declarations, there is a article that specifically it should be entitled termination and has separate provisions on what the termination percentage and requirements are under the declaration, in addition to what 718.117 says.
Okay, excellent. So we've gone through all the questions. I think you've provided a plethora of information when it comes to condo terminations and what are the challenges and what are the liabilities. Any closing remarks as regards to tips or any golden nugget you have for them to take with them?
Yes, as I mentioned, the number one tip that I could have is just try to stay in front of any questions, any plan of termination, any offers, owners, board members, and management. Just make sure that once your community is approached, owners are being aware. Owners, once you hear of a potential offering being circulated, make sure that you're not just throwing that away in the mail. Please read it. Please understand the deadlines, because it's unfortunate once plans are approved and owners are left in a situation that they perhaps thought they had an option to proceed and there being in a forced sale. So just please stay on top of it. Thank you so much for having me here today. It's one of my favorite topics to talk about these days. And it's something, like I said, given the current market and statutory considerations with reserve funding, I think a lot of these communities will be seeing offers or marketing for termination. So thanks for having me.
No problem. Always a pleasure to have you on. It's always a pleasure to work with your firm as well. I know we do a lot of work together. So thank you for everything and the team behind the scenes that make this happen. As for myself, as Lindsay said, I want to kind of add to that is just really the communication is what's key. If you're in a situation where you're finding you're in a prime piece, your prime location, and you're going to see some hefty reserve requirements coming to your association, it doesn't hurt to get the conversation going. Many times I see that sometimes they're concerned with the conversation of how residents are going to react. It's your fiduciary duty to present to that business, to those members of that association, options. And if the option is to sell, that option exists and what the number looks like. That way you can put your residents in a position to potentially succeed or say, look, this is not for us. We're going to take this direction, and this is the vision that we have for our community. So again, communication is key. And lastly is making sure that you're working with your partners, with both management. If you're going to make that termination, don't hesitate to let them know. That way they know where they stand. They may be able to assist you throughout this process. We were involved in it. We didn't take it as, oh, we're going to lose this account. We said, okay, we're going to help the association get through this. We know when this is going to terminate, and we move on from there. But it's very important to, get the partners involved, management, your attorneys, your accountants, and so forth. And that way you're making the best business decision for your community. And in this case, you're going to have the members involved because you're going to need their vote for this process. So as always, thank you for attending. We had a kind of a 50-50 split between board members and managers. So very proud of the managers that were on this call, getting educated, getting a strong understanding of how the process works. It's what's coming. Unfortunately, not trying to fearmonger here, but it's just the truth. And with the board members, proud of you as well, taking the time to educate yourself, get some additional knowledge, and do what's right for your community. We will be posting this webinar on our YouTube page. Siegfried would also share it as well. So if you have any questions, don't hesitate to reach out to Lindsay or myself. And thank you all again for attending one of our webinars. Thank you again, Lindsay, and thank you to your team and Siegfried.
Yes,
Have a great one.
Thank you.
Bye-bye.